the Delhi liquor scam case in which a CBI court, a designated CBI court, came out with its verdict and acquitted. Acquitted is the wrong term actually. Discharged all the accused, Arvind Kejriwal, former Deputy CM Manish Sisodia, and many others.
It's a welcome surprise. Rarely do courts in high-profile matters discharge the accused. Why is it that investigating agencies do not do their homework before actually putting a matter up to in a charge sheet?
Are we seeing a regime where the investigation agencies are just doing what they are being told to do without caring for their own professional reputation?
I think it is time for the investigating agencies to introspect very, very deeply. The point is that the investigating agencies so far have been doing the same job that some bad students do.
Does this not really sort of, introduces a lot of cynicism in the entire process by which our rule of law is being conducted?
Stop calling it the rule of law. The rule of law happens inside the courts. What happens outside the courts is the law of the rulers. If the ruler tells the investigating agency, fix this one, the investigating agency will go and fix somebody, irrespective of what the investigating agency thinks.
If 95% of the cases are against the opposition, and those who join the BJP, the cases are dropped. That's also proven by examples and data. What is called the washing machine. Some people call it the do big heart now.
Common citizen now lives in an atmosphere of terror.
Hello and welcome to this special discussion today on The Wire. We will talk about the fallout of the Delhi liquor scam case in which a CBI court, a designated CBI court, came out with its verdict and acquitted. Acquitted is the wrong term actually. Discharged all the accused, Arvind Kejriwal, former Deputy CM Manish Sisodia, and many others who were cited as accused by the prosecution, CBI. So, what has caught the attention of both the political and the legal community is that this is a case where the CBI court has discharged the accused. Now, I must explain the difference between discharge and acquittal. Now, discharge is when a case is not found fit enough to even go to trial. There was prima facie, the court found that there was no evidence to even take it to trial. Whereas acquittal, in legal terms, happens after a trial commences and after trial concludes. Now, so this is indeed a big slap on the face of the prosecution, CBI, and indeed a slap on the face of the ruling regime, which used the Delhi liquor scam, so-called liquor scams case to virtually finish off the Aam Aadmi Party and send half the senior cabinet members to jail, and the rest is history, of course. So today we will try to understand both the legal and political aspects from a very eminent senior advocate, Sanjay Hegde, who's besides a legal expert, a senior advocate, also is an activist. Sanjay, welcome to our show. So please tell us, how do you view this, the way this Delhi liquor scam case, the way the CBI court has delivered this verdict and its fallout, both legal and political?
It's a welcome surprise. Rarely do courts in high-profile matters discharge the accused. There is a tendency to let trials go on, even if you know that the evidence may not warrant a conviction, or that there may be a shortage of evidence. Courts tend to say, okay, let's see, let the evidence unfold, let the defense put out its case, and then I'll make up my mind. Here is a court which has said, okay, show me the evidence. Is this material enough to begin a trial? And thereafter, once it has seen that there is no evidence which shows evidence of a money trail, it has proceeded to discharge all the accused. See, what is the essential case? The essential case is that Delhi's liquor policy was changed, and as a consequence, some people benefited. Those people who benefited are alleged to have paid off for the change in policy. There are, a kind of resonance with what was very popularly called the 2G scam. Nobody remembers that at the end of the trial, the trial court judge said, look, I've been waiting every day in this court for years and years for the prosecution to come up with evidence. You didn't come up with evidence, and as a consequence, I have no option but to acquit.
Yeah.
Here, the judge has, at a prior stage itself, said, look, you don't have the evidence. This matter should not go to trial. The fallout, I suspect, will be huge. There will have to be questions asked, and some heads ought to roll. Why is it that investigating agencies do not do their homework before actually putting a matter up to in a charge sheet? What is your charge sheet? Your charge sheet is a compilation of the evidence that you have and laying out the case as to why a court should send it to trial. It is like a student who submits his examination paper for it to be evaluated. Now, if on evaluation you do not pass, you do not have the minimum passing marks, why should things go further?
Yeah, true. So, Sanjay, you rightly kind of observed that charge sheets, the way the investigation agencies have been behaving, conducting themselves, and the way charge sheets are being filed or not being filed, and the way trial itself is either cases are not going to trial 10 years, in this government's 10 years tenure, one can cite many cases which have been initiated but either not gone to trial, bad charge sheets which have not been framed, which the courts have not accepted yet, or if they have accepted, trial is proceeding very, very slowly. I can recall just one or two cases which I'll cite to you. One is the Siddiq Kapan case, where even before he had reached the spot in UP, where he was trying to do a story. Basically, so it was about a Dalit woman who was raped and killed. Gang rape. So in his case, the charge sheet was some 4,000 pages, and even the courts observed the charge sheet was badly done. It was not properly properly folioed in the beginning, which is a procedural requirement, marking the page numbers and the properly connecting it to the various events, etc. And that case also, it's still sort of pending, not gone anywhere. The Northeast Delhi riots case, on which you have written so much, also commented, also is a case where the investigation was so shoddy that many lower courts commented on the nature of the investigation, nature of witnesses, statements gathered. And there is, of course, the National Herald case which is going on and on. And the again, a special court uh, some time ago, a few months ago, had very, very strong, made a very strong, gave a strong order on the maintainability of the FIR, etc. So when you put all these things together, Sanjay, what is your conclusion? I mean, are we seeing a regime where the investigation agencies are just doing what they are being told to do without caring for their own professional reputations? Like in this case, in the Kejriwal case, the court has observed that there should be an inquiry against the IO. Now, do you think that senior officers of CBI and ED, Enforcement Directorate, should be worried that at some future time there could be inquiries opened against them for the way they've conducted themselves? How do you see this whole package, the way things are panning out, rule of law, white collar crimes, the way they're being treated outside the judiciary?
Well, I think it is time for the investigating agencies to introspect very, very deeply. The point is that the investigating agencies so far have been doing the same job that some bad students do. That you don't know anything about the subject, but you write pages and pages hoping that the examiner will give you marks per page. So therefore, you have this 5,000 page, 10,000 page. You try to bury the process under paper, and you tend to say, justify it by saying that we did not want to leave anything undone, so we did everything, and despite that, ultimately people got out. It is time to now bring this process to heel. You should have, we've long talked about it, independence of prosecutors. Do you have an independent prosecutor ever who can tell the investigating agencies, look, boss, you don't have enough to go for the case to go through. These are the gaps in your evidence. Fill those gaps before you proceed any further. Courts are pretty lenient with the timelines. They keep extending the time to file a charge sheet. And what the investigating agencies do is to file one skeleton kind of charge sheet naming an unknown accused. Then you tend to rope in other people. There is a process of evergreening charge sheets. And because of this process of evergreening charge sheets, what happens is that accused who are arrested often do not get bail. So it's not only that process is the punishment, you now have punishment by process. What does the investigating agency do? The investigating agency said, first arrest the person. Yeah. Said, okay, I'm going to file a charge sheet in 90 days, then give me 180 days, and so on and so forth. Then, while the first person is still in jail, then you say that investigations have revealed that these other people may also be involved. So we are filing a supplementary charge sheet. The first person also, then questions of his bail sometimes tend to get deferred. If you arrest a person under these so-called special laws, previously it used to be the NDPS Act and some terrorism-related acts. Now, because of the expansion of the PMLA, the Enforcement Directorate has a kind of carte blanche to arrest people and tell the courts, no, you can't release them. You can't until the twin conditions are met. What are the twin conditions? You have to hear the prosecution first, and the judge has to be satisfied that the person is not guilty, and that if he is released, he will not indulge in that crime again. What kind of law is this? Because nobody can predict the future. And the judge cannot say that a person is guilty or not guilty without going through the entire evidence. And that's what the Supreme Court held in a judgment called Vatali, which was a 3-judge judgment delivered in the case of some terror financing in Kashmir. But that gets applied all across the board to even ordinary criminal actions, like some Prevention of Corruption Act case in Kanyakumari. Then the ED then steps in and says there are proceeds of crime. We will also arrest. So all this leads to a Kafkaesque system of allowing investigating agencies, and by default, those who control the investigating agencies, the ability to put somebody in prison and keep him there for almost as long as they want.
Yeah. So Sanjay, talking about procedures, it's very interesting that you mentioned the 2G case. I remember that in the 2G trial, none other than Anil Ambani, one of the accused, actually turned to be a witness. He became a witness, and in the course of the trial, he was, instead of helping, the prosecution, it was found that he was really not doing that. He was actually doing the opposite. At which point, I remember UU Lalit, who was then a special prosecutor in that case, later he became Supreme Court judge. He even in the course of the trial recommended that he be reverted to being an accused. And those are the kind of cynical games that were played in the 2G case. And we all know, the rest is history. We all know where Anil Ambani stands today. And similarly,
we also know where A. Raja stands today.
Exactly. And similarly, Sanjay, I wanted to comment on this. The liquor scam case, the Delhi excise policy case, also had all these kind of machinations, where, witnesses were being produced and they selectively, what they said was being put in the charge sheet, which the court has observed. And one accused was turned into an approver. And then that accused, Sarath Kumar, who happened to be a director in Aurobindo Pharma, South-based company. And he was part of the South group, which conspired with the North, with AAP, in the so-called, the charge sheet mentions the South group. And later, Sarath Kumar, he turns approver. And 6 months after that, his company pays 25 crores as electoral bonds for the BJP. Now, is this, how do you look at this? I mean, do you think this would also have, in some ways, influenced the judge, although this is not exactly, doesn't form part of the case per se, his contribution to the BJP electoral bond after he turned approver? So what do you think? I mean, does this not really sort of, introduces a lot of cynicism in the entire process by which our rule of law is being conducted?
Stop calling it the rule of law. The rule of law happens inside the courts. What happens outside the courts is the law of the rulers. If the ruler tells the investigating agency, fix this one, the investigating agency will go and fix somebody, irrespective of what the investigating agency thinks.
Yeah.
That is the real problem, isn't it?
Yeah.
So once they go in a predetermined fashion, then they and arrest somebody, then they try to bury that person under tons of paper and clog the entire system. I actually think that there is a solution, a remedial solution.
Yeah. What is that?
The solution is this. Franklin Delano Roosevelt, as President of the United States, made a decision. He said, if it is important, you will write to me on one page alone.
Yeah.
Because that concentrates the mind.
Yeah.
And
exactly.
Concentrates the mind of the person reading it, the person writing it.
Yeah.
That principle then went into Procter and Gamble in what was called their one-page memo. They had an
Okay.
entire format for that.
Yeah.
What I would like to see is judges insist on a skeleton argument, a skeleton submission, saying, look,
Okay.
this is how, including flowcharts, this is how the prosecution proposes to lay out its case. This is it.
Okay.
And there in that one page, you put in the references. This is where you will find it in the evidence. This is where you find it, etc. So once the prosecutor's mind is concentrated, knowing well that there will be a trained forensic audit on the other side, both by the judge as well as by the defense, then a lot of this unnecessary surplusage and verbiage and trying to bury things in paper, that can be handled.
Sanjay, it's interesting you're saying this because some time ago there was a judgment by K.V. Vishwanathan, Justice K.V. Vishwanathan, which precisely said this, that all the charges should be made out in just in a few pages in an affidavit, so as to avoid things getting buried under whatever 4,000, 5,000 pages. Do you recall that order?
I do recall that, but I would insist on one page alone, rather than you can support it by a 5-page affidavit, this, that, and the other.
Yeah.
Put up, see, I think it was Mark Twain who once wrote to somebody saying that I did not have the time to think through and write a short letter to you. Therefore, I will write a long letter.
Yeah. No, that was, even Hemingway once wrote an article to Times London, long one, and he wrote that he didn't have time to write a shorter one. So there's a story about Hemingway also in the same context. So now coming back to Sanjay, now how do you, there are some other interesting aspects of the way the CBI and ED work together. Now, this has been established by several court orders that ED cannot proceed against somebody without a predicate offense.
Yes.
And FIR already filed by either the CBI or the police. Now, ED had been on its own, had been violating this, and they've got a major rap on the knuckles by several courts, high courts. But what we are now seeing is the CBI FIR has been, like in the AAP case, Kejriwal and others, they've been discharged. The CBI FIR has fallen. But now, do you think that ED should also now close the case? Because I'll tell you why I'm asking this question. There's another case similar. There's a CBI case that was against NDTV, Mr. Pranay Roy and his wife. It was about a bank loan that they took from ICICI, which they prepaid, and it was obviously a bogus case, just to harass them. It was a pure harassment case, which went on for 5-6 years, and it was dropped some time ago, much after Adani's takeover of the channel. And surprisingly, the CBI, all the defense arguments that were cited by Pranay Roy, saying how he had fully followed the rules in taking the loan and prepaying. CBI cited those arguments to say this case now doesn't stand after 5-6 years. Then subsequently, based on that, ED had filed the case, but ED is not withdrawing that case. So how do you view this? I mean, ED is acting as law unto itself. Is that the case? And we all know that ED's record of the total 5,000 plus cases that they filed ever since PMLA, in Parliament they've replied their conviction rate is some 0.6%. It is pathetic. In any other country, there would have been a parliamentary inquiry against ED. I mean, how do you look at ED's law unto itself behavior?
If I can make a very, very bad pun, the ED is often used to cure electile dysfunction. Wherever there is a politician who you need to turn to your side, you unleash the ED. And why is it? It is because the ED functions under the PMLA, which has the draconian provision with regard to bail, with the twin conditions that I spoke about.
Yeah.
Now, the problem is that the PMLA came in because of the need to curb arms and narcotics. That is your international commission, international covenant
Commitment. Yeah.
under the financial FATA and all that.
Yeah.
But what we have done is we have expanded the scope of the ED to cover almost any kind of domestic crime, including the Prevention Corruption Act and all that.
Even when there is no predicate offense, right? Yeah.
No, there has to be a predicate offense. But the question is, just let me, for your viewers' benefit, that things which a law which is required for Pablo Escobar types is now used for maybe a routine sarpanch, his corruption. Then what the ED also does is to insist that just because there is a complaint pending there, just because some appeal is pending there, the predicate offense is still alive. What was the great hurry yesterday after a 500-page judgment to immediately rush to the Delhi High Court and file an appeal? So that the ED can say, look, there is an appeal still alive. Therefore, my ED case still stands.
But there is a view that unless Delhi High Court stays the special CBI court order, ED cannot proceed. Is that true?
That is correct. That's correct. That will be an argument. And at the end of the day, if the ED proceeds now in any fashion, it will be seen as almost malified exercise of power. Prosecutorial malevolence will be ascribed to it.
Okay. Now, Sanjay, coming to the larger politics, I remember once, if you recall, Abhishek Singhvi had gone to court with a broader case before the Supreme Court, where he cited data to show that 95% of all the political cases of corruption, etc., malfeasance, corruption, etc., were against opposition parties. So thereby he was trying to suggest to the court, I think Chandrachud was the Chief Justice and it was before him, he tried to suggest that there is a clear malafide. Of course, the Supreme Court then said that they can't make an omnibus kind of assessment of that. It has to be case by case. So therefore, that petition did not go anywhere. But then what Abhishek Singhvi said there and presented with data was obvious to everybody, right? If 95% of the cases are against the opposition and those who joined the BJP, the cases are dropped. That's also proven by examples and data. What is called the washing machine. Some people call it the do big heart now, given the scale of what is happening. Now, how does the opposition deal with this? Do you think the opposition should now intervene in Parliament and come together and raise these issues and ask for some, with a unified voice, ask for some basic minimum in the way CBI and ED conduct themselves, in the way these cases are being conducted? For instance, as you said, making out a charge in a like a 1-page or 2-page thing, note, making it very clear, and doing starting trial. I'm sure there must be some legal procedures also that trial should begin at a minimum within a certain period, or a case should be completely done within a certain period. I remember when Mr. Modi came to power in 2014, he had part of his manifesto, BJP manifesto, a special tribunal for political cases where cases could be started and discharged within a limited period of time, 2-3 years, whatever. Where has all that gone? Should the opposition party now demand that in a unified voice? What do you think?
I do not want to get into the politics of it as to whether an opposition. The people of India demand it. See, it's
Okay.
like this. We talk about all these uh, cases which with political overtones, which everybody then gets on, and the investigating agencies are wary of. But look at this unbridled power, as a consequence of which the any ordinary man, when faced with even the remotest possibility of an ED inquiry, will shivers and almost gives up. Only yesterday there was a story of a maid who conned her employer, saying that there was an ED raid, or sent people pretending to be ED officers. The
You're
only
right.
reason why that
Yeah.
old man found out that they were not ED officers was because his grandson was a lawyer appearing for the ED.
Yeah. Mhm.
So
You're,
a common citizen now lives in an atmosphere of terror. And if your administration operates like that, if there is a huge public demand, then the opposition or even the ruling party will come to their senses. Now, what I see is, even if the opposition were to become the ruling party, there is no guarantee that they will not weaponize the ED against their opponents.
so what I'm saying, Sanjay, if some legislation is proposed, for instance, then it should sort of it should cut across party lines, isn't it? Like there was a
Absolutely. But
proposed legislation on doing away with criminal defamation, right?
yes,
So criminal
yes.
defamation doesn't
First,
exist anywhere
cut.
in the world.
Yes, yes. Similarly, this one, cut down the ED's mandate and the PMLA, restrict it to drugs money and arms money in accordance with your international commitments.
Right.
Otherwise, maybe one day we'll even have dowry offenses where the ED starts taking cognizance.
Yeah. So that could be one of the solutions. Thank you very much, Sanjay Hegde, for talking to us and giving us a view of the law, the agencies, the investigation agencies, and the judiciary. Thank you very much. Thanks.
Thank you, Venu.